we will do justice to that. Okay. So on my last video, I said we'll be talking about succession. Succession. Yes, it's a very vast topic. Very vast topic. Very vast topic. It's very vast, and it's technical. Succession. What is succession? You know, when a man dies, um, his estate will be shared. You know, succession is simply put that succession is a kind of an orderly way, an orderly method of distributing someone's power, property, um, whatever etc. to another entity. Okay, is a way of giving out what you used to have, and what you used to manage to another person. You give out your power, your property, your estate to another person. That is what succession is, an orderly way, to hand over your power, your property to another person. That is what succession is in a simple way. That is what succession is. Then, when we are talking about succession, there are two words that we always use: testate succession and intestate succession. Remember, when you talk about succession, we are talking about will, how we pass will, what happens, what makes people to write will, what happens with will, So when you're talking about will, you should know that it's when somebody dies. Okay? When somebody dies, we'll start talking of the person's will, because a will cannot be read, or it cannot be effective until the maker dies. That is why we use the word ambulatory, but forget that word. Okay, you don't use will until the maker of that will dies, until the death of that maker of that will. Okay, until he dies, that will not be effective, or will not take effect. Okay, so when we are talking about testamentary will and testate will and intestate will, it means, one, testate will, you said something before you died. Intestate, you didn't say anything before you died. Okay, so if we are talking about testate will is a will where the maker of the will said, this my house, give it to this person. This my car, let this person manage it. That is testate. Okay, he said something before he died. Okay, this my company, let my first son manage it. This my shoe, give it to my friend. That is testate. He says something. And when we're talking about this testate, we can also say that this testate, it can come in a customary will, or otherwise. Yes, you can say a testate will is customary when the maker did not write it, when it's oral. A customary will is oral, is mainly the character is oral, is mainly stated in the presence of some family members, maybe important family members or principal family members, or just say family members who are witnesses to the oral will. Please, I don't know if I will stand up from this sick bed, but in case I don't stand up, my brother, let my son do this, let my daughter do this, let my friend do this, let this person do this, let my adopted child do this. Okay? Yes. You can still write it too. It doesn't change the character. You can write it in their presence and say, yes, this is what I want, this is my wish. If I'm no more, this is my wish. Okay? They will respect it. They are supposed to respect it. If you say it like that, they are supposed to respect it. Okay? So when we talk about tested will, you said something before dying. You said something. This is your wish. This is what you want people to do for you. This is how you want your properties to be managed. This is whom you will like to manage your property. Okay? That is tested. Then if you want to do it if you say it orally, it's customary will. It's customary will. I'm just trying to, find a way to put this thing so that anybody that listens to the video will understand it. Okay? Yes. It's customary when you just say it in the presence of some family members who are witnesses to what you are saying. Who are witnesses to what you're saying. You can also write it down and show them, let them see, and keep it for you. It doesn't act, it doesn't work only until the death of the maker of that will. Am I understood? If you don't understand, just write whatever thing you did not understand. I will explain better. Okay? Then when we're talking about intestates, okay, no, testate will under the acts, under the statutory acts. When we're talking about testate will under the acts, you will write it. That's the character. It has a character. You will write it. You will sign it. And you will acknowledge it. Remember, the customary will, you can say it oral. You can say it oral. Or you can write it and people will give it to people to keep for you. But statutory will, it is a must. That is its own character. You must write it. It must be under writing. You can't say it oral. You can't say it oral. You must write it. You must sign it. You must sign it. And you must acknowledge it. We will bring out this topic bit by bit. We will be taking it bit by bit because it's so large. And if I keep it at this, you might not get anything out of it. So the video will be coming, batch by batch regards this topic succession. It's too large and technical, but I will try as much as possible to bring it out bit by bit. So you will write, sign, and acknowledge under the statutes. Note that your signature must be in the presence of two witnesses. Two witnesses. In the presence of two witnesses. They will be with you. You will sign it in their presence. And they will countersign. They will acknowledge, they will sign it back. They will put their own signatures there as witnesses to your will. As witnesses to your will. Then we say that intestate, remember we said testate and intestate. Intestate will is, or intestate succession is testate and intestate when you make a will and when you don't make a will. Intestate, you did not make a will. Intestate, you didn't make a will, you didn't say anything, you didn't say your wish, you just, passed on, and then let them do what let them do the needful, or what they think they know is better for them, they should do it. And in most cases, in fact, not just that, whether you have a will, people fight. Whether you don't have a will, people fight. I don't know if it's hunger that is causing it. If you are educated, you are read, and you're doing well, I don't think you need anything from your father. If you're doing well, your father has trained you, and you start your business and you're doing well, you're progressing. I don't think you will start trying to fight over maybe one upstairs that your father has, when you yourself, you've gotten like 2 or 3 upstairs. You have where you live, you have your car, you're taking care of your family very well. I don't see the reason why you should go and start dragging your father's parlor. Okay, I know it's beyond that. Yes, there are some people that their fathers has big companies and stuff like that. They will try as much as possible to secure those places and not allow their brothers that they are not comfortable with to handle these things. Okay, yes, I understand very well that in some families, maybe the first son that is supposed to step into the shoes of your father and hold these things on trust for himself and for his siblings might not be be responsible as the second or the third child. And in that case, you wouldn't want him to take care of that company, especially when there is no will. Because if there is will, I know that the man knows the capacity of his children. And in that case, when the man says, let my first son not manage, let my second son manage, the first son will go to court and say, why will I be the first child and my father is giving the mantle of leadership to the second child, and there will be a problem. But if there is no will, if the second steps in, the first might still fight. Let me know your thoughts about this. Let's talk about it. Okay, let's discuss about it. Let me know your thoughts. Just put your comments on the comment section. So intestate is when you did not write anything. When you did not write anything, and your property, your estate will be shared according to your custom. According to your custom, Yoruba, Hausa, Igbo, if you are a Muslim, they have Islamic law. It's recognized. Your property, your estate will be treated according to your custom. According to your custom. Things will be shared according to your custom. There are some customs, they don't recognize female children. They don't recognize female children, but they've forgotten that female children, most of them take care of the family more than the male children. But because of their culture, they don't recognize female children. They will share the property among the male. There are some cultures that both female and male children will partake in the estate of the man or in the property of the man. Both the female children and the male children will partake. There are some cultures, even even if the male child is the youngest one, he is the person that will get something. The girls that are older will not get anything. There are some cultures, even if a girl is the first child, what they look at is the first child, whether a male or a female. The first child takes this. Yes. If it's your culture, let me see it on the comment section. There are some culture they share only to the children. They don't share to the wives. They share only to the children, not to the wives. Okay? So we have different cultures. When you pass on without writing anything, without making a wish, the culture that guides you or that guided you during your lifetime will guide the distribution of your property or your estate, as the case may be. Will guide the distribution of your estate. So we have a lot of things to talk on succession. We have a lot of things to talk on succession, but I will bring it out little by little so that we understand. It's a very vast topic, so that we'll understand it very well. We said that succession is a way of passing your things to another entity, passing your things to another person, your children, your descendants, your dependents. That is succession. You were managing this company before. Now you are no more. Your first son is managing the company. That is, your first son has succeeded you. That is it. Then when you make a wish, this is how I want my thing to be. That is will. Taste it. Okay? I said that tested will can come as a customary will, where you make it oral. You call your brothers and tell them your wish, what you want. You tell them what you want. This is what I want, please. If I'm no more, let this happen, let this happen. That is your wish. Even though people go to court now, they fight over will. They fight over wish. I don't know, somebody cannot have his will read in peace. Children must fight. We watch Nigerian movie, most of the things we see there, they happen. They happen. It's not just movie. Most of them are true life stories. You know, this is what I want, this is what I want. At the end of the day, you say, for we are, no, it will not happen again. No, it's not like that. It's not like that. And they will start going to court because of will. Okay? So when you make an oral will, it's customary will. You can write it down anyway. It doesn't change the character. It's customary will, but it will be in the presence of witnesses. Then the other one will be in the presence of witnesses, but you must sign it, write it and acknowledge it, and the witnesses must sign. You must sign in the presence of your witnesses and they must sign. That's the difference. If you need any other thing more, just hit the comment button. We will elaborate. If you're a lawyer and you come across this video, please, you are very free to contribute. Thank you very much. Remember, we are Kaka's Corner. Kindly like, follow and share our page. Subscribe to our YouTube channel and follow us on TikTok. See you.